If you served around burn pits, Agent Orange, or other toxic exposures, and you're sick now, there's a law you need to know. It's called the PACT Act. Normally, to win a VA claim, you'd have to prove your illness came from that exposure. That proof is where a claim can get denied. For a long list of conditions, the PACT Act takes that step away. The VA now assumes the connection. This doesn't stop with the veteran. If you lost someone who served, this law may reach you too. We'll get to that. So here's what's ahead, what the PACT Act actually does and whether it covers your service and your condition, then how to prove it and file without paying for a medical opinion, how to reopen an old denial, and what survivors are owed. This is the Veteran Field Manual. Plain English VA benefits, straight from the rules with nothing to sell. Everything here is educational only. It isn't legal or medical advice, and these lists do change. Subscribe so you don't miss the next chapter. The PACT Act is a 2022 law that expanded VA benefits for toxic exposure. It's named for Sergeant First Class Heath Robinson, a soldier who died of a toxic exposure illness. In its first year alone, it delivered more than $1.85 billion in benefits to veterans and their families. So here's the problem it solves. Normally, a claim has to show three things: a current diagnosis, an event or exposure in service, and a nexus. A nexus is a medical opinion that says your service caused your condition. Getting one can cost you money. An examiner can disagree with it. That's where you can get denied. With a PACT claim, you don't prove the nexus, the law provides it. For a covered veteran with a listed condition, that condition shall be considered incurred in service. The word is shall, not might. You prove two things: your qualifying service and your diagnosis, and the law supplies the link between them. The condition doesn't have to appear anywhere in your service records. It can show up years after you got out and still be presumed connected. So, are you covered? It comes down to when and where you serve. There are 3 exposure groups, and then a few other paths in case none of the 3 fit you. The first group is burn pits in the Gulf War or after 9/11. The second is Agent Orange in the Vietnam era. The third is radiation from a few specific cleanup missions. Each group covers its own list of conditions, so we'll take them one at a time. The first group we'll talk about covers exposure to burn pits, the open-air pits the military used to burn waste. 2 service periods count here. If you served in the Gulf War, in the Southwest Asia Theater on or after August 2, 1990, your service counts. That's Iraq, Kuwait, Saudi Arabia, and the countries and waters around them. If you served after 9/11 in Afghanistan, Djibouti, Egypt, Jordan, Lebanon, Syria, Uzbekistan, or Yemen, it counts too. Either way, the covered conditions are the same. For burn pits, the covered conditions come in 2 lists. The first list is cancers. You don't need an exact match. If you've got that service and your cancer's one of these, you're covered. Brain, gastrointestinal, head, neck, kidney, lymphoma, melanoma, pancreatic, reproductive, and respiratory. The second list is breathing conditions: asthma diagnosed after service, chronic bronchitis, chronic obstructive pulmonary disease, chronic rhinitis, chronic sinusitis, bronchiolitis, emphysema, granulomatous disease, interstitial lung disease, pleuritis, pulmonary fibrosis, and sarcoidosis. If your lungs, sinuses, or airways were never the same, check this list. Before we leave Gulf War service, there's a separate path that runs on it. This one isn't about a named condition at all. It's for illness that never got a clear diagnosis. If you served in the Southwest Asia Theater or in Afghanistan, and you've had symptoms for 6 months or more that no doctor could name, that can be covered too. That includes chronic fatigue, fibromyalgia, stomach and gut problems, joint and muscle pain, and headaches. A few infectious diseases count as well if they showed up within a year, like brucellosis, Q fever, malaria, and West Nile. So if you came back and never felt right, you may still have a claim. So that's the burn pit group, plus the separate Gulf War path we just covered. The second group is exposure to Agent Orange, the toxic herbicide used in the Vietnam era. That coverage already existed, and it still takes 2 things: a qualifying location and a condition on the Agent Orange list. What the PACT Act did was add to each. It added qualifying locations: Thailand, Laos, Cambodia, Guam, American Samoa, and Johnston Atoll. It also added 2 conditions: high blood pressure and a blood condition called MGUS, or monoclonal gammopathy of undetermined significance. That's an abnormal protein in your blood. It usually causes no symptoms, but the VA now covers it. Those 2 are just the new ones. The full Agent Orange list is much longer, so check it at va.gov. So, if you were denied years ago because you weren't boots on the ground in Vietnam, but your duty station is on the new list, the reason for that denial is gone. Keep that in mind. We come back to it. So that covers Agent Orange. The third group is exposure to radiation. That coverage already existed too, and the PACT Act added 3 sites to it: the Eniwetok Atoll cleanup in the late 1970s and 2 nuclear weapon accidents in the 1960s at Palomares, Spain, and Thule, Greenland. If you took part in one of those, you're a radiation-exposed veteran and a list of cancers is covered for you. Check the radiation list at va.gov. So those are the 3 groups. There's also a catch-all, so you don't count yourself out. Even if your location isn't on any of these lists, a documented toxic exposure in your service record can still support your claim. If you don't see your base or your country anywhere in this video, but your exposure is on paper, you may still have a case. Not sure what you were exposed to? If you're enrolled in VA healthcare, you can get a free toxic exposure screening. It's a conversation, not an exam, and not a claims decision. Someone asks about burn pits, Agent Orange, radiation, and Camp Lejeune water, and points you toward the benefits you may qualify for. Not enrolled? You can sign up for VA healthcare at va.gov, then ask for the screening. Every condition in this video is in effect right now. The VA rolled these out faster than the law even required, so there's nothing left to wait on. The list still grows though, so check the current one at the VA's hazardous materials page before you file. Never trust an old printout or even this video a year from now. This is the part that's on you, and it's 2 pieces. The PACT Act connects them for you, but it can't hand you either one. The first is your diagnosis. A doctor has to have diagnosed you with one of the covered conditions. You don't prove it came from your service. That's the law's job now. You just need to have the diagnosis on record. The second piece is your service. Your DD-214, your deployment orders, and your service personnel records are what show it. You're proving one thing, that you were in a covered place at a covered time. Nail this down, because the presumption depends on it. If your records are thin, or a deployment isn't clearly documented, you're not stuck. Unit records, travel vouchers, and statements from people you served with can fill the gap. That free screening can help connect your service to a known exposure. Pin down where you were and when. Get that right, and the law takes it from there. For a covered condition with qualifying service, you don't need a nexus letter. The law supplies the link, so don't pay for a medical opinion that buys you nothing. When you file, you need just 2 things: proof of qualifying service and a current diagnosis of the listed condition. You submit them on VA Form 21, 526EZ, and state plainly that the condition is presumptive under the PACT Act. That one sentence tells the reviewer exactly which rule applies. 3 traps to skip. Don't pay anyone for a nexus letter because the law already gave you one. Don't trust an old printed list. Don't assume you're not covered without checking because the list is bigger than it used to be. Now we get to the move we told you to keep in mind: reopening an old denial. If you were denied for one of these conditions before the PACT Act covered it, that denial isn't the end. When a change in law removes the reason you were denied, you get to reopen the claim. You do it with a supplemental claim, VA Form 20-0995. You cite the PACT Act as the change in law, and you attach your service proof and diagnosis, same as a new claim. Here's why it matters for your wallet. Reopening on a change in law basis can protect an earlier effective date. An earlier effective date can mean back pay, sometimes reaching toward your original filing. The exact date is case-specific, so the move is to file and let the VA set it, not to leave it on the table. The VA says that if it thinks you're newly eligible, it'll try to reach out. Don't sit and wait for a letter that may never reach your case. File the supplemental claim yourself. Now, survivors. If you lost a veteran to one of these conditions, the PACT Act may reach you. As a surviving spouse, a dependent child, or a dependent parent, you may qualify for a monthly payment called Dependency and Indemnity Compensation, DIC. It isn't only DIC, you may also qualify for a survivor's pension, burial benefits, CHAMP VA healthcare, education benefits, and home loan eligibility. The reopening move from earlier works for survivors too. If your veteran was denied service connection before the law changed and later passed, you can pursue it now on that same change in law basis. You don't have to do it alone. A veteran service organization like the Veterans of Foreign Wars, the American Legion, or the Disabled American Veterans can help you file for free. So can your regional VA benefits office. 2 quick clarifications before you go. First, Camp Lejeune. Its contaminated water is toxic exposure, but its disability presumption is separate from the PACT Act and older. If you served there at least 30 days between August 1953 and December 1987, a set of conditions is presumed under its own rule. Part of the PACT Act that touched Camp Lejeune was a lawsuit, a separate money claim in court, not your disability rating. We give it its own chapter. Second, the PACT Act is one of several presumptive paths. There are others for chronic conditions that appear within a year of service, for former prisoners of war, and for tropical diseases. If PACT isn't your situation, one of those might be. We cover them in the Presumptive Conditions chapter. To recap, if you served around toxic exposure and you're sick, the PACT Act may already cover you. Find your group and check your condition against its list. Prove your service and your diagnosis. File on the 21-526EZ with no nexus letter. If you were denied before the law changed, reopen it with a supplemental claim, the 20-0995. If you lost a veteran to one of these conditions, look at survivor benefits and get free help filing from a veterans group or the VA. Before you go, thank you for your service and for sitting through all of this. It's a lot to take in, and you showed up for it. If this helped or you learned something new, share it with a veteran who could use it. Like it so more people find it, drop a comment if it cleared something up, and subscribe for the next chapter. If you want all of this in writing, the whole field manual is free at veteranfieldmanual.com. Free chapters and free tools to help with your claims journey, nothing to sell. This is the Veteran Field Manual. Take care of yourself out there.